the petitioner has chosen to come to court. He has not chosen to go and present his case in a marketplace. Leave the courts to do their work. And this begins from council. I have seen in the print media, I have seen on TV, some people appearing, we shall defeat this case. This is the forum where you can defeat the case. This is the forum where you can succeed to overturn the outcome of the presidential elections that was held on the 14th and declared on the 16th. Nowhere else. We will not take kindly to anyone, more so council, or the parties who have chosen to come to court, who have been dragged to court, now thinking that having had their day in court, they must also have another day elsewhere. We are here because you believe in the rule of law, which is a commendable thing. We are here because you believe, left to do their work, this court can do something. Leave the courts of law to sit down and render justice, as is their mandate to do. Let us not misuse social media. If we choose to go to social media to inform, let us give factual information on what transpired in court. That is permissible. Not this disparaging and mud throwing and so on and so forth. For those of you who are old enough, you should know the alternative to a court of law. It is until you're put with a situation where you have a military tribunal. We have seen this before, handling purely civic matters like this. Then you'll cry for a court of law. Some of us are old enough, we saw this happening, where kangaroo justice was meted out. We saw it in this country. So my appeal to those who are old enough like me is to remind them to recall, and for those of you who are unfortunately not as old as I am, to know that the court of justice, the court of law, it may not be perfect, but you don't want the alternative to the court of law. So whatever you do, let us strengthen the courts of law to do their work. And this does not apply to the presidential elections petition only. There are other petitions which are coming, parliamentary and for local government. Let us act with responsibility. This is our country. I do not own it more than you do, nor do you own it more than I do. We own it together. We can destroy it together, or we can lift it up together. And posterity will judge us either in commendation or very harshly, depending on how we handle the opportunity that is present before us. This is about determining whether the grievance before this court has got merit or not. Not about winning. It is only when you seek to win that you can say, I'm going to deny this document, I'm going to be this. It is. And let me also say, it's not about the petitioner. The question before court is about whether and how we can have an election which everybody is satisfied by. So please, the moment council pursues a winning attitude, by all means, by all means, then we deviate from the purpose for which we are here. And elections are not about the candidates. It's about you and me. It's about our country. So I expect total cooperation. I expect decorum. I expect that we pursue. We are going to investigate. We are going to inquire into the grievance which has been presented before court. Whatever the position is, either two, subsequent to this sitting of court today, we expect total cooperation. We expect that learned counsel, whose responsibility is primarily to this court and then secondly to their clients, will do everything in their power to see that justice is done. Learned Attorney General, your head of bar, you know this. It includes availing your opponent, in quotes, authorities which they may not have, which would help their case, but you have it. That's really what it means. If Mr. Kiwanuka has some authority which Council Lubega has never heard of, and it improves on Council Lubega's case, the professionality of legal practice says you avail it to the other side. And that's how we should proceed. Yes, it's what makes the legal profession beautiful. It is why you're called learned. We're not just educated, but learned. So it comes with responsibility. Then finally, and this to both parties, to all the parties, the four parties, to the media.
With information, I think again to set the record straight. I did not say that any communication with respect to what I said has been shared with counsel for the second respondent. We have been corresponding with the Electoral Commission.
No, that's okay. That's okay. My point is, from now, yes, whatever has transpired, you know, we can spend the whole day saying you did, you didn't do, but I am saying from now, I expect, I do not want learned counsel whose responsibility is to me primarily. Then because of that, they have a responsibility to the petitioner or to the respondents to look at one another as if they are opponents. They are not. They only believe that their client has a case. The other person says it is their client who has a case. And you have to present that before us. So I expect that the Attorney General will give you maximum cooperation, counsel for the first respondent, the second respondent. They will all give you maximum cooperation. And similarly, they may want some information from you. We expect it is, yes, it's not a one-way traffic. There's need for reciprocation. What you need from them, if they need something from you, I expect total cooperation. And that's how it should be. Thank you. So the strict timeline I have given for filing affidavit evidence, you'll be lucky if you will be allowed to file an affidavit evidence outside of that timeline. So you really got to go and do work. Because there's a great danger. It will lead to serious ramification if we expand the latitude that you can file an affidavit whenever you want. So the timeline I've given for these actions is really strict. It is also strict on the court. The court must, all those volumes, the court must determine within a space of 10 days. So similarly, you must do your work within the timeline court has given. Thank you.
For the record, my lord, my name is Chiriwa Chwanuka, counsel for the first respondent. My lord, pretty much everything is clear, save for one issue on electronic evidence. We understand that the same will have to be filed with affidavits and served on the parties so that we can be able to challenge it either with counter evidence or challenge it legally. Because the dates were given for receiving electronic evidence which was outside the time for service of affidavits. But we just want to clarify that by the time they are presented for viewing, they would have been introduced properly using an affidavit so that we can be able to put in affidavits in response and or challenge them legally.
That's the law, no?
Yes, my lord.
Yes.
Most obliged.
So you cannot bring an electronic evidence except by affidavit.
Most
By the
obliged.
time we reach that date, it should be on record.
Most obliged, madam.
Then we determine its reception and admissibility. Yes. Any
My Lord, I can only say it's axiomatic, and we shall follow the rules.
you follow the rules. Thank
Yes.
you.
How can I have spoken to them? No sooner had I said them than they showed exactly. Yeah.